thank you very much, because now instead of focusing on my presentation, I'm thinking what paragliders and school in Guatemala have in common. I have to admit, I don't have fancy slides, and I don't have any exciting news for you. Nothing about paragliders. I'm going to talk about some dangerous trends which now happening on the level of the European Union and in the US, which are going to change the game completely on how industry operates in relation to investigation of internet crimes and also policing illegal content online. And in this regard, I would like to discuss two big issues which are now on the table. To answer this question, whether the industry and cloud providers in particular have to or should become internet cops, we have to have a look at two big issues. First of them is how industry is dealing and is going to deal with the collection of electronic evidence. And here we have two of the most imminent dangers for you as for cloud providers or for players in the DNS system. EU proposal on electronic evidence collection and the US Cloud Act. And the second big issue I'm going to discuss later is the role of tech companies and platforms and hosting providers in addressing illegal content issues, content monitoring and content takedowns. What are they doing now? What are the current legal regimes? And don't worry, I'm going to talk about this in simple language, because I don't know how many lawyers are here. And also on the meta level, I would like to discuss the concept of intermediary liability for illegal content versus this senseless concept of intermediary responsibility, which is now raising its ugly head, at least on the level of the European Union in different discussions. So what is in there for the electronic evidence? We have United States and EU entering what I would like to call legal arm race. And they're racing down to the bottom, creating uncertainty for internet providers and also throwing away the safeguards for consumers and users. What is in there in these two legal documents? Just a disclaimer, one of them is already a law, US Cloud Act, and another one is probably going to become a law soon on the level of the European Union. So what did the United States do? Under the Cloud Act, US President can enter executive agreements with foreign authorities. So they can demand the data from the providers which are located in the US directly, without the approval of the US police or judicial authorities. And vice versa. According to this act, US law enforcement can access the data remotely, no matter what their location is and which provider they are located with. How did EU respond? Instead of championing human rights, safeguards, and its domestic players, strengthening their role in terms of like where customer would like to locate the data to make them, kind of safe for consumers and for themselves, EU came up with a proposal which is even worse than US Cloud Act. According to this proposal, any company which provides service in the EU, and this will touch basically any company, not only Google or Facebook or this tech giant. It is also about cloud providers, small and medium enterprises. It's about DNS registries and registrars. Basically anyone, any platform, any intermediary would have to, first of all, designate legal representative in Europe, even if they have no legal presence in Europe and no headquarters and no office. And secondly, they will have to address all requests for data coming through from the foreign legal authority without approval of the judicial or law enforcement in the country where they are located. What does it mean? I don't know how it sounds right now for you, but just a bit about the current process of collecting electronic evidence. So, for example, I'm a cop in Germany. If I want to access the data in Belgium, I have to ask, first of all, my court in Germany to approve it. Then I send it to Belgium. It's getting approved by Belgian court or Belgian police. And then it goes to the internet provider or to a platform. So there are several safeguards. First of all, my court checks if this is in accordance with the domestic law, and then Belgian courts checks if all the safeguards are in place from the Belgian law perspective. We have this dual criminality requirement, and we have very different data protection laws. For example, in Germany, you cannot intercept or access the data of priests, lawyers, notaries, but in France, you can easily accept the data of the priest. So in between these two countries, requests for the data of the priest might not be addressed. And this is only one of the examples. There are so many different legal protections, like, for example, for which crime I can get access the data, for which crime I can request communication data and metadata. This is all going to be disregarded. Providers are going to respond to the foreign authority directly. And the question here is not even if the industry is going to become a cop. No, it's much worse. Industry is going to become a quasi-judicial authority, which will have to check the foreign request, not only for the purpose of compliance with their domestic law, but also to check if this request was sent in accordance with the law of the country which sent it. Think about it. It is about you. It is about you, cloud providers. The reasoning for such demands and for such legislative proposals are that mutual legal assistance take a long time, it is slow, but think, providers will have to do, according to the new EU proposal, in 10 days, they will have to address the request, and in emergency situation in 6 hours, that takes weeks, sometimes months, for law enforcement to address. How fair is this? How fair is this to turn them into those who are going to assess those requests? And I do believe, and I'm going to concentrate now a bit on this EU e-evidence proposal, because for me, in terms of mutual legal assistance, in terms of legal consequences, it's hitting the bottom rock of anywhere we can possibly go in collecting electronic evidence. First of all, it completely, as I said, it completely disregards existing mutual legal assistance mechanisms. And they do not exist on a whim. It is not kind of artificially created obstacle that these requests have to be verified against the law. As I said, there are so many safeguards in this regard. There are so many differences in national legislations that are only law enforcement and judiciary can assess. And law enforcement and judiciary are basically in a capacity to assess. And this creates incredible lack of legal certainty for the internet providers. How are they going to verify the facts? Why are they in a position to verify them at all? And think about all those big platforms that are championing the market. How the small providers are going to designate legal representative, how they are going to find those who will assess legal systems in the foreign countries and in their national countries and compare this request and decide if it's going to be addressed or not. Article 14 of the evidence proposal imposes this burden of addressing request or rejecting request on the provider. Before, it was the responsibility of the court. And it is a very dangerous trend. There are no safeguards for providers in this regard. They're between the rock and the hard place. So on the one hand, they're responsible for handling the data of their customers properly, for the privacy of data. On the other hand, they're responsible for addressing the law enforcement request of the foreign country. And it creates unnecessary burden both administratively, cost-wise, and legally. And one of the important points here is that the state and the providers have completely different regimes of accountability. if we look from the point of the international law or human rights law or Charter of Human Rights, it is the duty of the state to guarantee the human rights of the citizens, of the users. This responsibility is now being shifted by this proposal to the internet providers. Why are they going to take this responsibility? And secondly, states are accountable to their citizens. At least in Europe, we are moving to transparency, we are moving to accountability, and I can vote for my government, but I cannot vote for who is going to be in the private company, who is going to assess my requests. So again, it is a complete legal uncertainty for the providers, how they're accountable, how they're going to perform those tasks. And it's completely unclear because normally when you have a request as a judiciary, you have the lists of crimes. Like, for example, these proposals say that it's 3 years threshold. You have the list of crimes, you can check the privacy safeguards about lawyers, priests, and whatever protected communications. In this regard, you are basically, if you're a judiciary, you have the list, you're accountable, you have the knowledge. But when internet providers are going to do this, they are going to go through enormous bits of information, putting the pieces together. With the legal borders that are not defined by this directive, they will have to go into national laws and just analyze them. And from the bigger perspective, on the meta level, think about this far-reaching jurisdiction. If US Cloud Act and EU Electronic Evidence Proposal is saying that EU or US can demand the data directly or can access the data directly, what actually prevents those regimes which we call bad guys to do the same? Of course they will do it. Of course, if EU has such demands, they might impose the same demands on the EU or US companies. And this will destroy further the regime of safeguards and mutual legal assistance. Is there any other way to do so? I do understand the frustration of the legislators. I do understand the frustration of the law enforcement. Nowadays, when any crime can leave digital traces, it is extremely frustrating when the evidence is located abroad. It is very frustrating that you have to go through all these lengthy process of approvals. But look at the EU mutual legal assistance system. The main argument is that mutual legal assistance system is slow and it's broken and it can't be fixed. As someone who is working on different projects in the mutual legal assistance, especially in the EU, I would say it's not broken. I travel around, I talk to police, and in the recent couple of years with the adoption of the European investigation order, the times for addressing the request changed dramatically. They reduced to 10 days or a couple of weeks, which is absolutely the same that this EU directive is trying to impose on the internet providers. The EU mutual legal assistance is not perfect, but it is not broken. And instead of redesigning it and imposing unrealistic demands on the internet providers, on the industry, EU would have been better to pay attention to the improvements of the European investigation order. They are better to pay attention to some projects that are going on now on the national level, on direct data transmissions. When you can, once a request is approved, you can technically access the data on the side of the provider, but you still have judicial approval, but then you have information within seconds. And these channels can be used instead of just throwing away all this system and coming up with some ugly stillborn child. But if we are going to use this directive, and my intelligence on the EU level is saying that it is indeed going to be passed, I believe that there should be clear mechanisms for the providers to challenge those orders. There should be clear borders of which orders can be addressed, which can be not. There should be safeguards for users and for providers both. What happens if provider doesn't address this request, or what happens if the request is illegal? There should be transparency on how these requests are being handled. But all in all, I'm a firm believer that the enforcement of law is the duty of the state, and it should never, ever be imposed on the private industry because of the different accountability regimes, because it is costly and it is completely unreasonable. And whatever depressing it sounds, I'm moving to the second part, which I find probably even more depressing and more worrying. The second part is about illegal content and policy in illegal content. And I'm not going, as I said, I'm not going to talk about EU copyright directive, which has been discussed right now everywhere. I'm going to focus more on the content which is clearly illegal or on policy and harmful content. And here again I have problems. This concept of harmful content emerged on the EU level and on the US level and in some other countries after all those debates about misinformation, disinformation, fake news and terrorist content. And I find this concept very vague and very dangerous because I as a lawyer do not understand harm to whom. What kind of harm? Who is going to assess the borders of harm? At least with illegal content, I can clearly say what is illegal, something that is prohibited by law. But when we are talking about fake news or disinformation or terrorist content, who is going to assess it? And who is liable and who is responsible for taking down this content and addressing this content if the legal borders of prohibition are not even determined? Let's have a look at the existing legal regimes. The notice and takedown procedures for illegal content, they actually exist for a long time, more than 2 decades. In the US, there is Legal Shield, Communication Decency Act, existing from 1996, I think. I'm sorry, which created legal shield against providers, saying that they are not responsible for illegal content unless they have knowledge about it. The same regime was established by the EU e-commerce directive in 2000, which, in addition to exempting providers from the responsibility for illegal content, especially ISPs, which EMEA conduit, said that hosting providers are not responsible unless they are aware about illegal content. And the main rule which was imposed by the EU e-commerce directive is that hosting providers cannot be obliged to monitor content proactively. So if you host the content or you are a platform, you don't have to crawl, through all these terabytes of information to see if there is terrorist content or harmful content or, God forbid, fake news. You don't have to. It is not yours. It is posted by someone. If you're aware, take it down. So this is the letter of law. Full stop. But what is the sad and ugly reality? Is that there are calls for providers, and especially platforms, to actually monitor this content. There is no law about this. There is a pure coercion, which is called self-regulation, and the creation of this concept of the responsibility of the intermediaries, responsibility of the platforms, and responsibility of the hosting providers. So instead of honestly going back to the e-commerce directive and redesigning it and saying, okay, we are not happy with the current framework of responsibility for illegal content. We want companies to monitor the content. We want them to take down upon their initiative. We want them to detect whatever content is harmful. EU is creating the new concept of responsibility, which for me, as for a lawyer, makes absolutely no sense. It's senseless. Responsibility has no legal meaning, but it does exist in this discourse, in this narrative. The second big issue I have with this concept of responsibility, which is being imposed right now on the platforms, and I see how it's going to extend on any hosting provider, is that it's not only about legal or illegal content. At least here we can see the borders. What is legal, what is illegal, what is prohibited? My problem is harmful content. Who is going to take decision what is harmful? Who is going to assess this? Who is going to assess what is misinformation, interference with election, political propaganda, and whatever is there? Is industry going to be turned into Ministry of Truth? Private censorship with no limits? How you basically assess that this is propaganda and not a funny article from The Onion? You know, I know that in Germany, for example, there was a case last year, or maybe even in last year, when the Twitter account, the mock Twitter account was taken down. The mock Twitter account, which was trying to make fun of far right, was taken down. So how do you distinguish satire from propaganda, or from illegal content, or from hate speech? And why is industry to be responsible for this? I would say again, I do not mind if the legislators come up with a regulation. I would consider it bad. I wouldn't welcome it. But if they want to, they must come up with a law. They must come up with something that will clearly define what is responsibility, what is liability, how it should be done, how illegal content should be defined, what is prohibited. Define the border of harmful content. Define the processes, the due process of taking this content down. Define the mechanisms to appeal. Because again, the hosting providers are going to be between the devil and the deep blue sea, responsible for customers' content, for taking it down, being liable in front of the customer for taking down content illegally. Who is going to assess it? And I also do believe that when we are talking about harmful content or propaganda, governments should put at least half of these efforts to educate the users instead of putting more and more burden of responsibility on the internet providers. And again, as with e-evidence, I do believe that the law enforcement is a duty of the state. State has clear mechanisms, especially when it's about criminal law, especially when it's about electronic evidence, especially if it's about illegal content. Criminal law was not designed to be flexible. Criminal law entails the highest degree of responsibility. Criminal law is the highest degree of governmental intervention into the life of a person, into a privacy of a particular person, into the business of internet providers. It cannot be flexible with, blurring borders which are not defined. The principle of legal certainty, the principle of legality, and this principle should be followed, not only in providing what is legal and what is not, in establishing the borders of crime, but also in establishing the borders and process, how we are dealing with this crime investigation, or how we are dealing with illegal content, or how we are dealing with anything that is illegal. And leaving this to the providers, it is absolutely unnecessary, and it is not fair, neither to providers nor to industry. So as I said, I do think that there are many calls on the national level, on the international level, for hosting providers to become content police. And I do believe that, very unfortunately, in some spaces it is going to happen. And if it is going to happen, I would like to see legal certainty and clear definition. I would like to see privatization of law enforcement which will not be overreaching. And I would like to see, most of all, due process and clear process for notification and remedies. So, answering the question, should cloud companies become internet cops? No. I could have just started with this slide and make us all go into paraglider or lunch, but they shouldn't be. But I do believe that with current legislative initiatives, unfortunately, they would be. They would be turning into cops. They would be turning into quasi-judicial authorities. And what really strikes me here is why industry so silent, why there is no resistance whatsoever. At least I don't see it. Human rights organizations, NGO, academia is trying to contribute to this debate, but I do not see industry coming up and raising their voices. Maybe telecom industry like Ethno submitted some responses to the e-evidence directive, but basically what is going on the European Union is happening on the sly. So my question here, which I have no response to, like counter question, should cloud companies become internet cops? No. But why is industry so silent about it? Thank you.